11 hours ago, Donald Trump suffered a devastating legal defeat, one that reshapes the next 72 hours entirely. A federal appeals court has rejected Trump's immunity claims again. I've reviewed the filings, and in the next 30 minutes, you'll see exactly why his legal team is scrambling, and why the accountability timeline just accelerated. The emergency stay Trump filed at 11 p.m., denied by 6:47 a.m., no oral arguments, no delay. What once looked like a viable immunity defense is now collapsing, as prosecutors in 3 jurisdictions move forward simultaneously. 17 former federal prosecutors have signed an amicus brief stating that Trump's conduct meets the legal threshold for insurrection. And in 48 hours, another major hearing moves ahead. Ready or not? Stay with me. I'll walk you through the precise prosecutorial timeline and the procedural pressure points most analysts are missing. Because this isn't just another setback. It's the systematic dismantling of Trump's entire defense strategy. If you value clear, fact-driven political analysis, like this video, share it. And subscribe to George Will Unfiltered for updates you won't get anywhere else. Less than 12 hours ago, the D.C. Circuit Court didn't simply reject Trump's emergency appeal. They delivered an unequivocal rebuke. The court issued a per curiam opinion, unanimous agreement among all 3 judges. The language is striking. Quote, former President Trump's alleged efforts to remain in power despite losing the 2020 election were unprecedented in our nation's history. That phrasing carries legal weight. The court is signaling that Trump's conduct falls outside any defensible interpretation of presidential authority. Here's what the ruling establishes: a comprehensive rejection of absolute immunity, a determination that Trump's actions were private conduct, not official acts, a prosecutorial roadmap identifying which charges survive appellate review, and crucially, a legal framework applicable to all pending criminal cases against Trump. This is historically unprecedented, not during Nixon's resignation, not during Clinton's impeachment. Never has a former president faced simultaneous criminal prosecution across 4 jurisdictions with immunity defenses collapsing in real time. The Supreme Court was supposed to be Trump's failsafe. Conservative justices could pause proceedings indefinitely. That hasn't happened. The emergency stay application filed last night contained 0 procedural indicators suggesting success. Trump's legal team believed Chief Justice Roberts would intervene to protect institutional credibility. As of this morning, Roberts hasn't acted, neither has Alito, neither has Thomas. Complete silence. A court majority clearly sees no emergency warranting intervention, and the names remaining silent are telling. Brett Kavanaugh, Amy Coney Barrett, Trump's own appointees, justices who secured their seats through Trump's nominations, have declined to rescue him. Senator Lindsey Graham stated publicly, "If the Supreme Court doesn't intervene, we're looking at a criminally convicted nominee in 2024. A Republican senator saying that about a Republican frontrunner. Let that register. Judge Tanya Chutkan has invoked the Speedy Trial Act. This mandates a trial date within 70 days once the immunity ruling becomes final. The appeals clock started this morning. By February 12th, the D.C. Circuit issues its complete opinion. That's 28 days, the entire window Trump has before prosecutors can request an immediate trial date. The mathematics are unforgiving. With a unanimous 3-judge panel rejection, En banc review is statistically unlikely. The Supreme Court has already declined one certiorari petition on immunity. If they decline again, Judge Chutkan's originally scheduled March 4th trial date becomes locked. And the timeline just compressed further. Trump's legal team is hemorrhaging personnel. They've reviewed the witness list: Mike Pence, Mark Meadows, Pat Cipollone, Cassidy Hutchinson. They've examined the documentary evidence, text messages, emails, and call logs. They've watched the January 6th video footage. They recognize this case is indefensible. Trump's response: non-stop social media posts alleging election interference. All capital letters. Attacks on Judge Chutkan. Claims of prosecutorial bias. Threats that his supporters will never accept this outcome. Then came the post that alarmed security officials. If these witch hunts don't stop, our country will face problems the likes of which we've never seen. A former president threatening civil unrest if prosecuted isn't political rhetoric. It's potential witness intimidation. It's a possible obstruction. Every post becomes potential evidence. And he cannot stop himself. He's engaged in a pattern of self-destructive behavior in real time. Here's what's happening now. Washington, D.C. is locked down. Capitol Police at heightened alert. New security barriers were erected around the federal courthouse. Counter-protest groups are mobilizing. Law enforcement is coordinating across multiple agencies. This is day one of a 28-day countdown to the opinion. 45 days until trial motions. 70 days of mounting tension. Everything we've tracked for 18 months is converging. The evidence collected by the January 6th committee. The documents seized at Mar-a-Lago. The grand jury testimony. The immunity appeals. All of it has condensed into this single moment. What happens next isn't speculation. It's procedure. Trial commences by March 4th. 6 weeks from now. Because Judge Chutkan's scheduling order was already established pending the immunity ruling. That 70-day speedy trial clock exists for situations exactly like this. Unanimous appellate rejection. An appeal to the Supreme Court is not automatic. Trump must file a certiorari petition. The court must grant review, which occurs in fewer than 2% of cases. Even if they accept the case, they could affirm with a one-line order. Either path leads to the same destination. Donald Trump becomes the first former president in American history to stand criminal trial while campaigning for office. Let me be precise about the charges. This isn't obstruction of Congress or abuse of power. These are conspiracy to defraud the United States, conspiracy to obstruct an official proceeding, conspiracy against rights, obstruction of an official proceeding. These aren't disputes over executive privilege or political disagreements. These charges target election integrity, peaceful transfer of power, and the constitutional foundation of democracy itself. That distinction fundamentally changes how independents and moderate Republicans evaluate what comes next. Once the D.C. trial begins, proceedings shift to Georgia. The RICO case is active in Fulton County under District Attorney Fani Willis. 19 co-defendants create procedural complications. Trump's defense team attempts parallel strategies across jurisdictions. Then the classified documents case in Florida accelerates. Conviction in D.C. requires a unanimous jury verdict, a high evidentiary bar. But the jury pool is Washington and D.C., where Biden secured 92% of the vote. Prosecutors possess testimony from Trump's own vice president, his own chief of staff, and his own White House counsel. Most people haven't processed this yet. Even if Trump somehow secures an acquittal in D.C., the Georgia case presents entirely different facts. A recording of Trump pressuring Secretary of State Brad Raffensperger to find 11,780 votes. A fake elector scheme with a complete paper trail. Breach of voting systems in Coffee County. That case doesn't rely on federal immunity arguments. Once conviction occurs in any jurisdiction, Trump faces sentencing before the November election. A convicted felon becomes the Republican nominee. The Secret Service would have to protect him in federal custody. Campaign events would occur via video from detention. Politically, he's neutralized. A criminally convicted presidential candidate without precedent in American history. Then there's the security dimension. Trump himself represents the most unpredictable variable. His reactions are increasingly threatening. Openly authoritarian language. Disconnected from legal reality. Posts suggesting chaos, if prosecuted, aren't empty bluster. They're threat indicators. Law enforcement is treating them seriously. FBI threat assessments elevated. Joint terrorism, task force monitoring extremist, communications, online. U.S. Marshals are preparing enhanced courtroom security during the trial. Preparing for potential violence, targeting prosecutors, witnesses, and the presiding judge. This should concern everyone, regardless of political affiliation. History provides clear lessons. January 6th happened after Trump spent weeks amplifying election fraud claims and instructing supporters to fight like hell. The next 28 days represent the most dangerous window. Trump recognizes conviction is increasingly probable. Control is slipping. When Trump feels cornered, historical patterns emerge. Escalation, attacks on allies, burning institutional relationships, and inviting chaos as a distraction. That behavioral pattern is documented across his business career, his presidency, and his post-presidency. Officials in Washington are operating on minimal sleep. There's a parallel criminal dimension unfolding. Jack Smith's referral doesn't conclude with the D.C. case. Evidence of witness tampering, obstruction of justice, and conspiracy to obstruct has been transmitted to prosecutors. If investigators establish that Trump directed the deletion of Mar-a-Lago surveillance footage, that constitutes obstruction of justice. A serious federal crime carrying up to 20 years. Retaining classified documents containing nuclear secrets and military attack plans. Title 18, U.S. Code, Section 793 carries a prison term of 10 years per count. He's charged with 32 counts. Here's what's happening behind closed doors. Multiple grand juries remain active. Washington, D.C., Miami, Atlanta, New York. State charges could arrive while federal proceedings advance. Tax fraud, bank fraud, campaign finance violations, insurance fraud. Each operates independently. We're in constitutional territory the founders anticipated, but hoped would never materialize. Multiple accountability mechanisms are activating simultaneously. Criminal prosecution, civil litigation, congressional investigation, disqualification under the 14th Amendment. Reports indicate confidential discussions among constitutional scholars regarding the 14th Amendment. Section 3. The Insurrection Clause permits disqualification from federal office without criminal conviction if someone engaged in insurrection or rebellion. Colorado and Maine already removed Trump from primary ballots using this mechanism. The Supreme Court will rule on this separately. The fact that this is even being discussed at the highest levels of government reveals how severe the situation has become. Meanwhile, the Republican Party is fracturing in real time. MAGA loyalists are doubling down. Establishment pragmatists are fleeing. Internal threats directed at anyone criticizing Trump. Republican election officials who certified the 2020 results are receiving death threats. The party was tearing itself apart. With 2024 congressional races approaching, many GOP candidates see an electoral disaster remaining tied to a criminally indicted nominee facing trial during campaign season. Polling indicates 32% of Republicans say they wouldn't support Trump if convicted. That's sufficient to render him unelectable. Senate Republicans in competitive states, Montana, Ohio, Pennsylvania, are creating distance. They recognize that Trump at the top of the ticket creates down-ballot vulnerability. Internationally, NATO allies are alarmed. A former U.S. president threatening domestic unrest while facing criminal charges for attempting to overturn an election is not normal democratic behavior. Adversaries are watching, calculating, and probing for weakness during the American institutional crisis. China is putting pressure on Taiwan. Russia is entrenched in Ukraine. Iran is expanding uranium enrichment. Domestic instability creates global security consequences. Right now, America appears vulnerable. Here's where we stand. 28 days from the D.C. Circuit opinion. Jack Smith has formally declared Trump's immunity claims without merit. Unanimous 3-judge panel rejection. The Supreme Court maintains silence. Capitol Police deployed at elevated readiness. Criminal investigations are accelerating across 4 states. Disqualification arguments are being litigated. The Republican Party is splintering into warring factions. Trump is escalating threatening rhetoric daily. This isn't media exaggeration. This isn't a partisan narrative. This is convergence. Everything built for 3 years is colliding into one narrow 70-day window. What happens in the next 10 weeks will shape American democracy, the rule of law, and constitutional order itself. But here's the deeper truth almost no one is discussing. Beyond immediate legal mechanics, there's a profound constitutional reckoning occurring. The D.C. Circuit's decision shattered a long-standing assumption that former presidents exist in a separate category beyond criminal accountability. That protective barrier is gone. The court entered the political arena and determined that Trump's conduct is sufficiently severe that criminal prosecution must proceed immediately. This changes the executive power balance permanently. For decades, presidents relied on political norms and institutional deference as protection. Avoid explicitly criminal conduct. Respect congressional oversight. Accept the election results peacefully. Those norms are no longer sufficient shields. The judicial rejection collapsed the timeline. It forced prosecutors to operate on a criminal justice clock, not a political calendar. Once that clock starts, it doesn't stop for polls, primaries, or party pressure. This is why Trump's Republican allies are panicking privately. They understand the trial isn't the end of exposure. It's the beginning of a public evidentiary avalanche. Trials bring witness testimony. Cross-examination under oath. Documentary evidence was introduced publicly. Video presentations to juries. Every layer revealed creates new legal risk, new political liability, new criminal exposure, not just for Trump, but for anyone who enabled him. The countdown is real. The evidentiary record is locked. The next move belongs to the federal court system. I'll be tracking every court filing, every witness revelation, every security briefing as this historic prosecution unfolds. Hit subscribe. Turn on notifications. What happens in the next 28 days will move faster than traditional media can process. Drop a comment. Do you think Trump gets convicted before the election? Or will he find a way to delay trials past November? I'll see you in the next breakdown. This constitutional crisis is far from over.